This is Democracy Watch. Mark, we've got some big news out of the Supreme Court. We've been watching the Texas gerrymandering case. This is a case that your law firm brought against Texas and its new maps. We had a lower court judge in Texas rule against these maps. Now it's made its way up to the Supreme Court. Can you explain what the news is here?
Yeah, so a three-judge panel in El Paso, Texas, blocked the Texas racial gerrymander from going into effect in a 2-1 decision. We could talk a little bit about what that dissent was because it was batshit crazy. But in any event, the case then went to the Supreme Court on an emergency appeal from the state of Texas to try to reverse this ruling, and they are desperate to do that. The case automatically gets referred from Justice Alito to the full court, Justice Alito being the circuit justice for the Fifth Circuit. And he put in place what's referred to as an administrative stay, which says basically nobody do anything until the Supreme Court rules. He has said that he wants our clients and the others on our side of the case to file responses in the Supreme Court to this petition, by the end of day Monday. So that's what everyone should expect.
Does this signal one way or the other what we might expect from the Supreme Court? Like, is there a world where Samuel Alito could have just refused to take up this case and said that the lower panel court ruling stands?
That would be highly unusual, candidly. I mean, the fact is that we fully expected this case to get referred to the full court. Most of the cases like this will get referred to the full court rather than a single justice disposing of it. That's kind of viewed as bad form among the Supreme Court members, right? Because they all want to have their say. So it was theoretically possible, but it was not at all likely. Now, the fact that he issued an administrative stay, that he didn't have to do, right? He could have said, okay, we're going to allow this blocking decision to stay in effect, which means Texas can't prepare to hold elections under the new map. They have to prepare to hold elections under the old map while this case gets litigated or decided on an emergency basis in the Supreme Court. But I wouldn't overread that. I mean, we've had lots of cases that have had administrative stays that are not highly predictive because they are issued by a single justice. So in other words, an administrative stay does not speak to anyone's intent or anyone's position, even technically the justice who issued the administrative stay, but certainly no one else on the court would have been consulted on an administrative stay. And it's relatively good news, if you're trying to read tea leaves, it's relatively good news that the case is on such a fast briefing schedule. I mean, by the end of Monday, the case will be fully briefed, and we will at that point just be awaiting a decision from the Supreme Court on the emergency petition.
So there will be no arguments?
No, I mean, the way this would work is, so this is the what's referred to as sometimes the shadow docket, right? This is essentially the ruling of the court pending the court holding oral argument and deciding the case. So technically what Texas asked was that the lower court decision be stayed and that it be put on the regular calendar to be heard later this term and decided by June. Okay, that's actually what Texas asked. The fact is that for purposes of the 2026 election, the emergency docket ruling, in other words, what they do in the first order of the court, will likely control, just because of the calendar, where we are, even though the case could then be put on the for full argument, and for disposition in June.
Okay, so I want to talk about what the options here that the Supreme Court can take when they finally hear this case and finally rule on this case. But first, I got to note for everybody watching that it is Mark's firm that's litigating this case down in Texas. Mark's firm that's fighting on the front lines to make sure that these gerrymandered maps, these racially gerrymandered maps, don't go into effect for 2026. So a small step that we can all take to show some support for the invaluable work that they're doing on the front lines is to sign up for Democracy Docket, which is the news outlet Mark founded to focus on everything voting and elections. So you can both sign up to support their journalistic endeavors and sign up to support what they're doing in the courts on the front lines to protect democracy. I'm going to put that link right here on the screen and also in the post description of this video. So Mark, as I was saying, what are the options now in terms of what the Supreme Court can do?
Okay, so the Supreme Court can deny the stay and say, nope, state of Texas, you have failed to meet your burden. And at this point, it is their burden of showing that the lower court decision was wrong. And then this map will not go into effect for the 2026 elections. And they could either at that point decide to hear the case on the merits or just summarily affirm the decision below. I don't think they're going to summarily affirm the decision below, although they could. So I suspect that it would then be scheduled for a merits oral argument, and then you'd have the usual, briefing and oral argument and a decision by June. So that's option one. Option two is that the Supreme Court could grant this emergency stay and set it for that normal argument. And at that point, it probably means that whatever the outcome on the merits in June, they would be using the new map in the meantime. So those are kind of like the two big decisions here. Do they rule one way or rule the other way? Then you get into the question of like what reasoning they might use. I mean, the dissent posited several could only be described as conspiracy theories. One that involved George Soros, which is mentioned 17 times in his dissenting opinion, along with me and my connection with George Soros. It's a unhinged opinion. But then in the government's briefing, there is also some really odd arguments that they're making. So we'll see what the court decides to do.
In terms of Purcell, which is this idea that you can't make changes too close to an election, this is oftentimes what Republicans will do when they want to make a change to their maps that they know is going to be illegal, that they know is going to be struck down, but they purposefully time it so that it happens too close to an election and then lean on the Purcell doctrine, which is, oh, well, we understand that it's illegal. We understand that it will get struck down, but it can't get struck down right now because it's just too close to an election. It would cause too much chaos. So, when you strike it down, it'll have to take effect for the next election cycle. And we're just forced to use this map right now through no fault of our own. We just have to rely on Purcell. So how does Purcell count in this instance?
I mean, there's no question. The state of Texas briefs and relies on Purcell as a theory. I have to be honest with you. If December 11 months before the election is quote unquote too close to the election, like we're starting to actually run out of runway. I mean, literally, there just was an election in November of 2025. Yeah. And if December of 2025 is then too close to November of 2026, I mean, at some point, we're literally going to run out of like months in the calendar that are not too close. So, I was quite skeptical of the Supreme Court and critical of the Supreme Court when a couple of years ago they held in a Louisiana rendition case that February of the election year was too late, but bringing it all the way back to December of the off
previous year, yeah.
I mean, like literally, there were just elections in November of 2025.
Yeah.
So, like, I guess unless the map was ordered, or the election law change was ordered like the day of the prior election, I'm not sure, like, how much earlier this could have been.
Mark, aside from Purcell, what arguments other than Purcell are they making?
Yeah, so this is a very strange brief because, they don't have a lot of natural tools available to them because the trial court made specific findings of fact, specifically said that after hearing the testimony from Adam Kincaid, the map drawer, that they believed that this was a racial gerrymander. It was not, as Adam Kincaid testified, a partisan gerrymander. And the Supreme Court is bound by those findings of fact unless they are referred to as clearly erroneous. It's hard to see how lay witness testimony where the judges are seeing the person live could ever be found to be clearly erroneous. So they're kind of in a stuck position because on the one hand, the court doesn't believe the lower court didn't credit Adam Kincaid's testimony there. And on the other hand, what my team and the others who brought this case were hanging their hat on was a letter by the Department of Justice, by Harmeet Dillon, saying you need to dismantle these coalition districts, and Greg Abbott saying I am calling a special session to do so. And that is, I think, even the state of Texas would acknowledge, if it happened, it would be a unconstitutional racial gerrymander. So I want to put up on the screen kind of how they handle this. They say, start with the statements from Assistant Attorney General Dillon, and those from Governor Abbott. Neither is a relevant state actor for purposes of the racial gerrymandering inquiry, because neither played a role in the drawing of district lines. They are federal and state level executive branch officials. Neither had any official or unofficial role in the map drawing. The testimony was undisputed that Adam Kincaid personally drew the map without staff, the governor, or legislators present. Now, this is kind of an extraordinary thing, Brian, because first of all, like under the bus goes the assistant attorney general for civil rights and the governor of the state. Like this is the equivalent of the lawyers for the state of Texas being like, don't pay any attention to the governor and to the Department of Justice. They are morons who don't know what they were doing. And they were, in fact, not, quote, relevant state actors, right? The governor was not a relevant state actor in this process. Like he was just kind of like this extraneous, crazy guy doing his thing. And then they go on to say that, and besides, Adam Kincaid drew the map without staff, the governor, or legislators. Like, think about that for a second. Their explanation is that Adam Kincaid, who, by the way, like I said, the lower court didn't believe this anyway, right? But that it was not a racial gerrymander. But the Republicans in Texas' argument is, don't pay attention to our governor. Don't pay attention to the Department of Justice. And don't even pay attention to our legislators, because none of them knew anything about this map. The map was actually drawn by this guy in Washington, D.C. without input from any of them. And, that really tells you a lot about what the Republicans are left arguing, is that a guy in Washington, D.C., a political operative, they say we're taking the shots from the White House, but not the Department of Justice, the RNC, but not Harmeet Dillon or the governor, and that this map then just sort of slid through the process, and that is what they want us to believe.
Well, if the Supreme Court does buy into this idea that it's too close because of Purcell, then wouldn't that have an impact on all the other pending redistricting? I mean, we haven't seen new maps out of Florida. We haven't seen, new maps out of some of the other Republican weapons. And so would that just kind of freeze the whole field? Because now the Supreme Court has said that anything from today forward is going to be blocked because of Purcell. And so what does that do to the rest of the country?
No, and I think for two reasons. First is legislative changes are not covered by Purcell. Purcell only prohibits courts from changing, doesn't prohibit legislatures from changing. So that's number one. Number two, what Republicans will argue is that the filing deadlines in Texas are unusually early. They take place actually in December. And so that states that have later primaries, we are not necessarily in the Purcell window. There's a lot of commentary that has suggested that the Supreme Court might have hoped to get the California case and the Texas case together and then kind of Purcell both of them. I don't have any reason to believe that's true other than people idly speculating. I do think that if Texas is found to be too late, then it would be, let's put it this way. I think if Texas is found to be too late, I think it would be quite something for the U.S. Supreme Court to then decide that California was not too late. And by the way, that would be assuming that the lower court struck down the map in California, which I don't think they're going to do. But I mean, there has been a lot of discussion about how these two states have been paired or haven't been paired in the public's mind, how been paired and haven't been paired in sort of state actors' minds. And some people have speculated about the Supreme Court, but I'm kind of doubtful about that.
On a 30,000 foot view question, we'll finish off with this. We have seen California's maps go through. We've seen the Virginia legislature move forward with their effort to amend their state constitution. And of course, there needs to be 2 consecutive state legislative sessions where they vote to push that forward. So we've already had one, and presumably in 2026 we'll have the second one. So they're already moving that process forward. That process will also move forward in very much the same way in New York. But aside from those states, there hasn't been any other movement. And on the Democratic side, with that said, we have seen movement on the Republican side. We've seen Missouri's map get redrawn. Now that's being challenged via a referendum, but as far as it stands right now, that map was changed. We've seen Texas's map get changed. Thanks to you, that was also blocked, but now that lies in the hands of the Supreme Court, so we'll see what they do. We've seen North Carolina's map get changed. We've seen Ohio's map get changed. And so are Democrats doing enough right now, as it stands right now, to counteract what we're seeing from Republicans, notwithstanding their lack of success in the courts, notwithstanding their lack of success when going up against you, but just more broadly, are Democrats doing enough to wield the weapons that they have at their disposal?
Look, I mean, just to be clear, we're suing not just Texas, but North Carolina and Missouri as well, and we're defending California. But to answer your question, look, we need Democrats in every state to take action. I mean, I can't have been clearer about this from day one, that, every state that has a Democratic trifecta should be doing something to redraw their maps.
Yeah.
Because, first of all, things could reverse in Texas. But even if they don't reverse in Texas, you mentioned Florida. But let's not forget, we have seen the state of Louisiana say that if the Voting Rights Act is cut back on or overturned, they're going to draw a new map. We just saw a few days ago a Republican legislator in South Carolina introduce a map to undo Congressman Clyburn's district. Right, we're going to see the Deep South become a major battleground of gerrymandering by Republicans over the course of the next few months. And obviously what the Supreme Court does in the Calais case can make that better or worse, accelerate it or slow it down. But make no mistake, like, people who think that the Republicans are stymied because they were not able to yet, and emphasis on yet, get Indiana to draw a new map, like, they still have a lot more states that they are going to work on, and they're going to be working on some states that are very MAGA friendly, and so I don't think we've seen the end of that.
Which is to say nothing, by the way, of what may happen to the Voting Rights Act at the hands of the Supreme Court.
That's right.
And the flood of map redraws that we would see in the aftermath of that. That could be anywhere from 20, 30 seats that we would see get erased if Republicans have that clear runway to do so. So again...
Right, and that's the reason why I say that every Democratic state needs to do it. I mean, to put it in perspective, Democracy Docket puts the number of potentially vulnerable seats at 30. Fair Fight, which is Stacey Abrams' organization, puts it at 19. The New York Times puts it at 12. So let's just assume for a moment that the New York Times is correct. Okay, I think that that's like truly the most the most baseline scenario. I think that they have a higher expectation of Republican principle than I do. But let's just say it's 12. 12 seats is a lot of seats that you could see. And so there are not currently enough Democratic legislators and governors in these states putting enough seats on the board to counteract the flood that we are almost certain to see.
Well, of course, we'll leave it there. Again, to support the work that Mark is doing and his team are doing on the front lines on this issue, please make sure to subscribe to Democracy Docket. That link is right here on the screen and also in the post description of this video. It's also an amazing resource that I use on a daily basis as well for all things legal news and voting rights. I'm Brian Tyler Cohen.
I'm Mark Elias.
This is Democracy Watch.